You are Juan Jose Serna. Mr. Serna, you now stand charged yet again with burglary of a motor vehicle. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please.
One moment, my system is. On March 20th, 2025, law enforcement officer was dispatched to a burglary of a motor vehicle that occurred in Old Navy parking lot in Harris County, Texas. A law enforcement officer spoke to two witnesses who viewed the incident. The first witness stated that the suspect's motor vehicle pulled up the complaining witness's motor vehicle, and the suspect wearing a camouflage hoodie got out and pulled on a door handle of the complaining witness's motor vehicle, attempting to open it. That set off the alarm of the motor vehicle, and the first witness advised that the suspect got back into a car, drove off to another area of a parking lot, parked and waited for the alarm to stop alerting. The first witness stated that once the alarm stopped making noise, the suspect jumped back over to the complaining witness motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complaining witness's motor vehicle. The complaining witness advised that she was walking up to a motor vehicle when she saw a Hispanic male wearing a camouflage jacket sitting in the driver's seat of her motor vehicle. The complaining witness stated that the suspect saw her walking up, jumped out of her motor vehicle, got into the passenger side of a waiting vehicle with an unreadable plate, and the complaining witness then heard the male tell the driver, "Go, go, go." Another law enforcement officer advised he was patrolling when the gold Tahoe that the suspect was observed in passed him at a high rate of speed. Traffic stop was initiated, and the law enforcement officer was able to send pictures from the witness showing the suspect motor vehicle leaving the location to another law enforcement officer who was able to verify the suspect motor vehicle. After further investigation and search of the suspect, a camo jacket was found in the rear seat, and a flat-pointed screwdriver consistent with the tool that would be used to break a lock on the complaining witness's door.
It was both that were attempting to B&B.
Yes, Your Honor. The defendant is the registered owner of the vehicle, but the motor vehicle was displaying a counterfeit tag that did not come back registered to
So Mr. Serna is the one that owns the Tahoe?
No, I apologize, Your Honor. Mr. Serna is the second. Looks like the second individual that was in the passenger, that was in the driver's seat whenever the complaining witness came out of the vehicle, is not the owner of the vehicle.
Judge, if I may, the complainant or the witness stated that she saw a Hispanic male with a camouflage hoodie. When they were pulled over, there's two people in the vehicle. The camouflage hoodie was not on my client, so I'm saying that there's no probable
They
cause.
have both of them in the car, being car.
The both of them in the car.
That's what, according to you, right?
Yes, Your Honor.
Both individuals.
Were in the car attempting to.
I have the
Because I thought it read that one person wearing a camouflage hoodie was in the car.
That was the second one. So the first person goes in, gets out, and then that's when the other one goes in. And then at that point, the complaining witness comes up and tells them to take off. Mr. Serna, let's go through your stuff. Theft of wire or cable. Theft, trespass, evading arrest, burglary of a motor vehicle, theft, assault of a family member, attempted burglary of a motor vehicle, theft, third, burglary of a motor vehicle, unauthorized use of a motor vehicle, evading arrest in a motor vehicle, burglary of a motor vehicle, assault, possession of marijuana, robbery, felony theft, assault, a prior, now a felony, another felony assault, unauthorized use of a motor vehicle, tampering with a government record, felony theft, unauthorized use of a motor vehicle, and now open, you have unauthorized use of a motor vehicle, felony theft, burglary of a motor vehicle, and possession of a criminal. What on earth do we need to do to keep our county safe? It's a rhetorical question, but I don't know what on earth we need to do to ensure that our county and our cars are safe. You live in Houston, dude. You don't live in Montana or Wyoming. People like their guns and they like their cars. And when you muck with the wrong person, they're going to shoot your ass dead. It happens time after time.
Judge, he's due in felony court tomorrow for his felonies. His bond is currently set at 10,000 for this misdemeanor. Can we reset till Friday to see what happens in felony? I'm asking the court to not revoke his bond. His bond is set at 10,000. I'm asking the court just keep it in place.
So there's nothing for me to revoke because he has not made bond on
In
the
felony, correct.
You're now being held at no bond on at least 2 of the felony cases that I see. If I don't know if you're going to get out, but if you do, I'm ordering you to have home confinement. I don't want you out at all because you scare me, Mr. Sonner. You really do. You're not going to be in possession of weapons. On your other ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. I don't want you using any dope. And let me be frank. If I find that you break any of these conditions on your bond, I'm going to make your bond so high you'll have teeth popping out. Do you understand? Do we have, who got the co-defendants? Do we have the co-defendants? No contact with the co-defendant, please, Felicia.
Still loading, Your Honor, I apologize. We have the co-defendant, Your Honor.
Say it again.
We have the co-defendant. I'll sit on the proceed.
Let me ask you this. You ever had a job before? Like a full-time job?
Yeah.
That's probably a good idea. When you have too much time on your hands, you become self-destructive. So with this, it's just a matter of time, dude. It's either dead or 50 years, man. Really? Life's too short to live in a 6x9 box for the next 50 years. All right. We'll set you for Monday.
Okay, thank you, Judge.
Mr. Senna?
You want to talk to me real quick?
Yes.
Talk.
Well, it's not gonna be quick, so,
It's okay.
okay, so I'm here
When is
on,
it ever quick? Anyway?
I'm here on Miss Gill. She's set, for a bond today, and
She in
so
custody?
she is, yes, Your Honor. And she has 1 pending felony, but she's out, she's out on a bond for that one already. She just has no bond set in this case.
I see bond sets. I see the FSGI's at 1,000. Yeah.
Okay. I talked
It
to
must have
the,
just gotten said. I don't know.
okay, is it a PR bond?
No. It's a
Okay.
show.
Okay, then if we could review it today, is that possible?
Absolutely. Do
Okay.
you mind, Deputy Etchigoin, do you need a translator?
No.
Do you mind me bringing up Miss Gill? Maria.
Is Donnie a PR bond then?
No. Additionals for the kid.
Okay.
All right. Good morning, Miss Gill.
Morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Harris County, Texas. regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallsville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So are
complainant,
you telling me that now it was intentional?
the complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck the vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Color.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
After.
Finish.
I'm so
please.
sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
In this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because
Wow.
allegedly
Yeah.
hungry and covered. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor.
May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. Has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
don't say anything.
how many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't say
me.
anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own,
You
right?
don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Well, I will let.
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now. All right? I'm not gonna raise it to 5, but I can't continue to give you a PR bond.
From employment too.
Listen,
Okay.
do not drive. It's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case
sir. Yes, sir.
and just, all right. Come on. Justin, I didn't want you to leave because I know you've been waiting.
Oh, no.
So this is it Lauderdale?
Lily.
Oh. Right. Good morning, Mr. Lee. Sir, you were charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 5th, 2025, the officer was conducting surveillance as part of a traffic crimes task force of motor vehicles racing westbound on Grand Parkway, and the officer observed the defendant's vehicle traveling in lane 2 and another vehicle in lane 1. The motor vehicle slowed down to approximately 30 miles per hour before launching at the same time in a competitive manner, accelerating to well over 110 to 125 miles per hour in an attempt to outpace each other. The motor vehicles raced 3 times, then pulled into a Buc-ee's. The officer observed the defendant, but was unable to locate the other motor vehicle involved in the race.
So then it says also he picked up a felony evading. He was on bond for a felony evading and now he's picked up this case, a racing?
It looks like that's the case, Your Honor. He was on bond for the evading.
I'm taking away your privilege to drive. You are not allowed to drive, Mr. Lee. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This is an affidavit that you're going to promise me that you're not going to drive. Do you understand? There's a burning building with 50 kids in it. I don't care. Do not drive. You mind filing those conditions as well, please? No driving.
No driving? Yes, Judge.
Have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Johnson. He will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, you pick up another case, I'm going to revoke it. And if I find that you're a danger to the public, I'm going to make it sky high. I will do everything in my power to protect my public at all costs. Do you understand? You want the same day as the felony?
Sunday is totally fine.
Yeah. Okay. All right, guys. I'm going to have you sign a reset. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. All right. Thanks, guys.
The felony is all the way in June 2nd.
Mr. Lee, 26, Your Honor.
Is it set for trial or something?
No, he was on that's a placeholder setting because it was a PTI.
What's going to happen with that? Is he still in the PTI?
It was, from my understanding, I don't know. I think it was some conditions he had to do and he's almost done with it. So I think he's close. I don't know.
So is that, do you know whether they're going to keep him in? Do they know about this?
I'm sure they know, but
Does the felony court?
I'm not attorney on that.
You're not the lawyer.
No, but they.
Okay. So let's just do this. Let's just do it right. We'll do a 30-day reset. And then I don't know what's going to happen upstairs. We'll see. You just keep us in the loop. Okay. All right. Good to see you.
Good to see you.
No, Chavez, Billy Chavez, no.
And it's Chavez?
Chavez.
Chavez-y Chavez.
How's your Chavez? Chavez.
Chavez-y Chavez. You know that? Young Guns? You ever saw that? Chavez-y Chavez.
That's a great movie. Part 2 is the best. Part 2 is the best one.
Nah, I don't know.
Do you like the first one?
They're both.
I like the second.
Got significant criminal history, huh? Not too new, but
She says she told the class. She said that this is what she's entitled to. She has.
is it Chavez or Chavez?
Your choice.
Sir, you're charged, well, sorry, you were wanted out of another jurisdiction. Your lawyer's asking for me to set you a bond. I don't know. I have to get to know you to see whether it would be a good idea to give you a bond because I got a lot of people here that are dangerous to my community and I don't want to, put anybody else in harm's way. I got to know that if I give you a bond, that you're actually going to go back, not become a danger. So we got to get to know you in the short time that we have. Tell me about it. And
Yeah, just one from Lincoln County, Wyoming for 3 counts of burglary, 3 counts of theft and property destruction. As opposed to a bond. While it was issued on February 26th of this year, he has some significant criminal history that we're concerned of. First off, he's actually currently on federal probation for a charge of stealing imported interstate shipped weapons from a licensed importer manufacturer. He, as the court also knows, he had a evading with motor vehicle in 2021. In that case, he accelerated for the stop sign, lost control of the vehicle, and hit a concrete barrier, and continued to drive and crash into a townhouse wall and fence. And then he continued to flee on foot in that case. He picked up that evading while he was on bond for a theft of a firearm and for a deferred S in our court. Looking at the facts of the theft of the firearm, it did resemble facts more similar to a burglary in that case. For these reasons, the state would be concerned about getting the bond.
you said he has 3 counts of burglary out of Wyoming?
Yeah.
Are they 3 separate transactions? Are they all one matter? Right, but is it one transaction in and of itself? Is it 3 different like days where we have 3 different burglaries? I guess, is it one criminal episode versus multiple?
Looks like they're one criminal episode and they all list the same date. I will also note, I had another fugitive on our docket a couple days ago, right? That had the exact same charge there as well. So I also think there's also another co-defendant.
Oh, we got a co-defendant. We didn't give the person a bond, did we?
No, I think that's,
That person was on federal probation too.
that I don't know.
Please.
Judge, so criminal history, that's
No bueno.
it's no bueno. This is a fugitive case, Judge. He's on federal probation. Yes, we threw that out there. He's on federal probation. He was picked up at federal probation, so he's complying with the requirements of his federal probation. Picked up there. Technically, I will say this, Judge. Talking about another co-defendant, I mean, that's got relevance on my client. He is his own
I agree
person.
with you. I agree.
So the biggest thing here is when this charge was filed. It was filed February 26th of 2025. We are in March 12th. He hasn't had an opportunity to go over there to Wyoming. This was just placed, and he's asking for an opportunity to go turn himself in, especially after he's been complying with his requisites of showing up where he needs to be. He was picked up at his probation that same day. So that being the case, I know it sounds bad that he gets burglary ×3, theft ×3, but he is presumed innocent. He hasn't missed a chance. We have no failure to appear, sounds like. And so we're asking for an opportunity for him to turn himself in.
Do you know when he got on federal probation?
2024, just the end of last year, October.
Let's go through your stuff. Since 2019, carrying a handgun in a motor vehicle, possession of a controlled substance, aggravated assault with a deadly weapon, possession of marijuana, theft of a firearm, evading in a motor vehicle, unauthorized use of a motor vehicle, federal probation for what?
Stealing imported interstate shipping weapons from a licensed importer manufacturer.
And now 3 burglaries, 3 thefts, 3 property destructions from
Property destruction.
1 property destruction from Wyoming. And you want me to give you a bond?
Yes.
No. The bill comes due. You scare me. If I give you a bond, my fear is that you will pick up another case. The only thing I like is public safety. And I give bonds on fugitive cases all the time when I have a feeling that they're not going to endanger my public. But since 2019, 1, 2, 3, 4, 5, 6, 7, 8 federal probation, 9, 10, 11 are here, and I don't even know what other criminal history has in other jurisdictions. Anything else in other jurisdictions?
Fort Bend, yeah, Fort Bend had a theft of property conviction from 2021.
Sorry, dude. Way too much baggage.
Judge, would you consider any amount for a bond?
No, he's too dangerous, man. Some federal probation, now he has 3 new cases. Just, sorry, man. You're too dangerous. Thanks.
Thank you, Judge.
All right.
I'll talk to you in a minute, still. Let's go.
Mr. Oates, you were charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, on August 29th, 2021, an officer was dispatched for a stalking call. The complainant stated the defendant and she were previously in a dating relationship but had been broken up for about a year at the time. The complainant stated she had to block the defendant's number because he was calling her excessively. On this date, the complaining witness noticed that the defendant's location was close to hers, which freaked her out because the defendant had moved to Oregon. She also stated that the defendant left flowers at her house and had told the defendant about 10 times to leave her alone via text message. The defendant refused to and said that he just wanted to talk to her. The defendant stayed outside the complaining witness's apartment all day and watched her. The defendant took a photo of the apartment and told the complaining witness to come outside. The officers detained the defendant. The defendant admitted to calling and texting the complaining witness numerous times. The defendant had sent over 80 text messages, which the complaining witness stated excluded.
So I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond, not have any contact with this person and not to be possessing weapons. Do you understand? Now, where have you been for the last 4 darn years?
So when I got out of jail, after my posted bail, I went back home to Oregon and and I started my life again and I just gave
It doesn't work like that. Now you go to jail.
And I understand that. See, when I was here, the lady told me, she was like, what are your intentions when you get out after bail? And I was like, I'm leaving. I'm not coming. I'm not going around her. I don't want to
Have an open case and you can't just take off and go to Abu Dhabi because you want to take the hell off. Start a new life. No, it doesn't work like that. Appoint him a lawyer, please. Take a seat for me in the jury box.
I'm here on Mr. Otis. He's the gentleman that found out he had a warrant and walked in. I am here asking if he would reinstate.
Come up.
His previous.
No, sorry. No, he's been gone for
So
3 years.
if I may, Judge, when he was originally arrested at magistration, the magistrate asked him what his plan was if she let him out. He said his plan was to go back home to Oregon, and she said, good, do that and stay out of trouble.
Are we supposed to take what he says at face value now?
And I just, Judge, he also has had no contact with the police for 4 years because he's had this warrant since 2021.
Did we look? Did you do an?
There's no FBI number, Your Honor. Let me check his state ID.
You need it?
I have it.
Okay.
Yeah, but because he had the warrant, if he had contact with the police in Oregon or Georgia or South Carolina,
Where are you living now, Mr. Oates?
I live in South Carolina with my 2 best friends. One of my best friends is trying to get me a job at the construction company.
Not now, while this case is open.
Well, I know, and that's how I found out about all of this, because I took my drug test and my background check, and they said that they couldn't hire me with an active case. And so as soon as I found that out, I called the court, and I couldn't get through, but I kept calling, and I finally got through. And then I told your assistant or one of your assistants that said as soon as I get enough money to travel down there, I will be there. I'll pay my bond, and I will take care of this case. And so as soon as
How old are you?
27, sir.
So what are you doing?
Right now I work for Dick's Sporting Goods, as in the process of trying to get the job as a construction worker, as a pipe fitter.
Okay, I'll reinstate, but I'll put a monitor on his ankle.
Okay.
You take off again. I'll never do this again. I'm not giving you another PR bond.
May I ask you a question, sir?
Sure.
So I do live in South Carolina. Am I allowed to go back? I can give you all the information. So I have to stay in
This
Houston.
case is from 2021. It's now time to take care of it.
Okay.
So I have
You
to
know,
stay.
really? Do you have an offer in this case now?
Not yet, Your Honor. We have spoken to the complainant. Being that it's so old, he's coming in on a warrant, we can reach out and get a quick trial, quick reset so we can talk to the complainant again, see where she's at.
And
Go from there.
Judge, we would ask for a 10-day trial setting.
Your Honor, that's just,
I
it's
mean,
confidential.
I know.
It's his fault that he's gone. I'm not gonna blame the state because of it.
That's unreasonable.
No,
Right.
no.
Apologize for that.
Do you see how many problems it creates?
Yes, sir.
Really,
I do.
You're supposed to live and you sign paperwork reflecting everything. So you need to read every single thing that you sign because there are consequences when you do whatever the hell you want to do.
Yes, sir.
All right, he gets an ankle monitor today. I'm gonna reinstate his bond.
Okay.
So I'll give you as much time as you need,
Okay.
whatever you guys, but this case,
We can do a quick setting, Your Honor.
within 30 days, it's a player trial. I'm not giving you more than 30 days. So
We'll talk about
you
it.
talk to her,
Yes, sir.
she'll explain everything to you, but
Yes, sir.
this case lives and dies within the next 30 days.
Your Honor, I'm here on Jennifer Gonzalez.
Come up, Ms. Gonzalez.
Yeah.
Guys, I'm gonna need your help on this. Come up. Please.
Your Honor, so the state has filed a motion to revoke community supervision on Ms. Gonzalez. I just spoke to Ms. Gonzalez about each of these, and so I'd like to be able to respond to them before the court if possible.
Sure.
Well, I would ask them to start with their motion though, actually.
So here's the deal.
Yes, Your Honor.
I have a lot of history with Ms. Gonzalez, a ton of history you don't know about. And we've gone round and round with her testing positive for alcohol, pills, meth, cocaine, alcohol, and it's literally been over and over, and it's been over. And now while she's on this probation, she tests positive for meth.
The night she tested positive for amphetamines, meth, and opiates, and on the March 5th, she tested positive for THC. She's also had skips on her device, 12 in February, 5 in January, 8 in December.
So I really think, and I warned her at the outset when she got on the probation that it was a problem, that I was going to put her in treatment. And I think that this is truly the only appropriate way to go forward because we gave her the opportunity to do this on her own and we multiple times and it's just not happening.
I have signed up for treatment, sir.
Ours is better. And I think that that's really the only appropriate course of action. So what I'm going to do is I'm going to amend your conditions to go into treatment. I think that that's, the evaluation is to do who.
Yes, go ahead, I'm sorry. ma'am.
In terms of the treatment, Your Honor, is it that you are wanting it to be jail-based treatment or could it be facility?
Well, I used to use,
It's too late. When we're helping ourselves to task casita, it's a 3 to 6 month program based on how to respond.
Your Honor, I have my father at home by himself, Your Honor,
gave you the opportunity, ma'am.
may I speak to you
Not gonna-
openly? Just for a second, Your Honor?
No, I've heard it before. You've told it to me time and again, and I've heard it time and again. And I'm sorry, but we gave you the opportunity. You're testing positive for these.
We can so Your Honor, I think when I spoke to her before, the only thing that we were talking about in terms of possible failed drug tests was a test that I showed from last month for marijuana. And so her explanation for that, Your Honor, is that she has broken her arm in 2 different places and pain management issues. Until we were here now, I'm only hearing about these other things. The only reason I bring it up, Your Honor, is because if she is having some type of issue with substances, I support treatment. I just question whether the jail-based treatment is the only possible option. Like, could she go into custody and be transferred from there into a facility where she has to be inpatient for 120 days or however many days you're requiring? Does it just have to be who? I guess is what I'm asking.
Here's the thing. Every time that I've done a TRAS on someone and I've deviated from it, we've paid for it dearly. They've either picked up a new WI, a felony, and I really take homage in the TRAS is because I tell you, every time we deviate from it and I acquiesce to something that you guys want or defense wants, we pay for it dearly and they end up in a worse position. And so that's why this has been an ongoing battle for 2 years. We've had an ongoing battle with Ms. Gonzalez for 2 years where it's been nonstop testing for this or testing for that. And I can show you the proof. I've got the proof. And now while she's on bond, she picks up a felony PCS. She's testing positive for these things, you know?
I would just add the felony PCS was
I get it.
dismissed
I get it.
It's my medication.
within 5 days of it being filed. So
I understand. I get it. But I really want to do what the TRS is. You know, I'm sorry, man, but that's what we're
I
gonna
can't
do.
leave my father, sir.
These are things that you think about when you're out there in the free world. We gave you the opportunity, Ms. Gonzalez. I'm not gonna argue with you.
No, sir, I'm not trying to argue with you, sir. I don't think the drug tests are, you're not, Your Honor, I'm so sorry. I'm not trying to say you're not looking at it correctly, but maybe you're not remembering, sir. I haven't
so
drank
maybe
in
she wants a
15 years.
motion, maybe she wants a hearing on, maybe she wants a hearing on revoking her probation. If
Not
that's what-
revoking it.
So he's not.
Not revoking.
No,
You're just changing the conditions.
what I'm saying is, my drug tests, sir, those are my medications that you're calling out, sir. The Adderall.
Okay, stop.
Yes, ma'am.
Just stop. I'm sorry.
Please, sir. Please, sir.
I'm not gonna argue it. No, we tried this.
Can you please tell, his name is Steven, he's around the corner. That they're putting me in jail. How long am I gonna be?
It's all up to you. If
Your Honor, I
all
will
the
do anything.
treatment,
I can't take my dad's not gonna have anyone to help him, sir. If we
I'm not gonna
please
argue
look,
with you, ma'am.
no, sir, I'm not trying to argue.
Had the opportunity.
I haven't drank in 15 years,
Thank
Your
you, Your
Honor.
Honor.
You have to look at my stuff. It's not right.
Over here, Jasmine.
Good morning, Ms. Howard. So you were wanted out from another state. Your lawyer is asking me to set you a bond. I don't know. You know, I've never met you before. I don't know you. I don't know how dangerous of a person you are. I don't know if I give you a bond, are you going to go back? I don't know. I know that you're going to tell me it's little gumdrops and rainbows but how you are on paper tells me who you are, because everybody tells me one thing, but when they get on paper, they're a completely different person. So I got to get to know you before we set you a bond. So Amy, tell us about Miss Howard.
Yes, Judge. She's wanted from Navajo County, Nebraska, for burglary, felony 2A, theft of lawful taking 5,000 plus, and conspiracy to commit a class 2A. State is opposed to a bond based, one, on the charges that she's wanted for, two, on the fact that she has previously been fugitive in airport.
Oh, really?
Yes, from South Carolina for robbery.
What happened with that case? Do you know?
I believe they picked her up in that case. Yes, they picked her up in that case. Her most recent conviction was also back in 2024 for an beating with a motor vehicle out of Fulton County. Day has also indicated to me that she is on federal probation right now.
She's on. That's out of Arkansas, Judge. That's what she's on bond for. She is on the leg, has the leg monitor on for that.
What's she on federal probation for?
What are you on probation out for?
I think like a drug conspiracy, John.
Where?
A conspiracy?
Out of where?
Arkansas.
That's the case at Arkansas, Judge.
Possession with intent to distribute, it looks like. Her release date is 2020.
So is that different from what she has in Nebraska, the federal probation case, or are you talking about, is that the same one?
Nebraska should be different. What she's wanted for right now is the burglary. So the basis of the probation, the federal probation would be the possession with intent to distribute.
Got it.
That's out of Arkansas. When she was in Arkansas, Nebraska put a hold on her, but they didn't come get her.
So let's get this right. Here in Harris County, in 22, you have a burglary of a building, a failure to identify oneself as a fugitive from justice, meaning you're trying to evade law enforcement. You have a prior fugitive case from 21. You have another failure to ID from 2024. You're on federal probation in some other state. You have another open burglary in Nebraska, and you had an evading in a motor vehicle in Montgomery County. And you want me to set you a bond? Should I? Really?
Ms. Howard, how long have you been in Houston? How long have you lived in Houston?
All my life.
Okay. You currently were on a probation and you have a leg monitor pursuant to that, correct?
Right.
Okay. And you had a leg monitor on you when they pulled you over, is that correct?
Right.
Okay. Did you attempt to flee from at that time?
No.
Okay. And that's what you're aware of that case up in Nebraska?
Not until my lawyer had told me to turn myself in, but they said when we made a court date for that.
I don't want you to talk about the cases now.
Okay.
How old are you, ma'am? How old are you?
I'm 24.
You're 24 and you have all those priors. You scare me, Miss Howard. You truly do. Because if I put my name on a bond, I don't want something bad to happen. And as history dictates, and as the paper says, it's sometimes we have to protect people from themselves because they're their own worst enemy. You know, you scare me. I can't give you a bond. It's hopscotch with states with the criminality. It can't just happen. And you have a prior one from here as well. I just can't do it, man. It just, at some point, it comes time, the bill comes due. That's now.
You already executed a waiver, Judge.
Okay. All right. Thank you, Ms. Howard.
Thank you.
Thank you. Thank you. You are on bond for murder and you've now picked up an assault case. Unacceptable. I'm revoking your bond. She goes with you. Michael, she's on bond for murder. She's lucky to even have a bond. I expect that you will comply with the bond conditions. And when you don't, there are serious consequences. As a condition of your bond, you're not to consume alcohol or illegal drugs, and I'm going to randomly test you. I also don't want you to have contact with the co-defendant, and I don't want you to go back to this nursing home. It's not an answer. The other gentleman that got arrested for the same exact thing.
That's my brother.
Okay, I don't want you to have contact. I mean, do I not have to tell you how you're on bond for 2 serious cases now? And it's just I'm going to protect my city at all costs. I don't care who you are. Just if I find that you're a danger, I'm going to revoke it. I'm going to make it sky high. Do you understand? Yes or no? I'm going to test you within the next couple of weeks. Don't use. You must stay in contact with the lawyer. If he tells you that he cannot get a hold of you because you're ducking and dodging phone calls, I will issue a warrant for your arrest. If you pick up a new case, likewise, I will revoke this bond and I'm going to make it high. That's fine. For now, we'll have you meet with Roxanne to get your bond conditions and then we'll let you go.
Your Honor, the felony court has a curfew that allows her to work. She does DoorDash. The curfew upstairs is from midnight to 6 a.m. because she does DoorDash in the evening. Would this court let its bond condition?
Curfew is what time?
midnight to 6 a.m.
She's allowed to drive from midnight to 6 a.m.?
No. She stops driving
So the
11-ish.
curfew is from 6 p.m.
No, from 12 midnight to 6 a.m. is her curfew in the felony court because she drives at night. And she stops around 11-ish.
On her license to see if she has a license. So you're telling me that she can be out from midnight? What hours do you work?
Home by midnight.
Yeah, I have to be in the house by midnight.
Yes, sir.
Judge, it's a different page that typically comes up. This says suspended.
I never had a license in Texas. My license is from North Dakota.
They're showing it's suspended.
Shouldn't be. I paid all my reinstatement fees already.
Take a look, Blaze, please. Can you help us out? Just to make sure. Especially if she's door dashing.
Yeah, we're seeing driver's license, non-commercial status suspended.
Say it again?
It says, driver's license, non-commercial status suspended.
The license is suspended, man. You're not allowed to drive. I'm telling you, they're looking it up and they're telling you it's suspended.
Right.
Yeah, I mean, for us, it says suspended. I mean, if there's
Okay,
anything-
you're not allowed to drive. If you want to drive, get the license reinstated, and we can take the condition off. If you're,
I've already took care of it, so maybe you just haven't updated, but I took care of the reinstatement already.
just don't drive. If you drove here, you're not allowed to drive home. I'm sorry. Your license is suspended. And then before you also drive, you must maintain liability insurance as well. So don't until let us know. I'm making it a bond condition that you're also not allowed to drive when you get it. Or if you get it reinstated, if you get it fixed, come back, let us know. We can take this condition off. All I'm asking you to do is follow the law. I'm not asking you to do anything, Pythagorean's theorem or anything. Just follow the law. Don't be a danger to my city. That's all I'm literally asking. Really. We're gonna have you sign a reset with Victoria. We'll have you meet with Roxanne for your bond conditions, and then you're free to go.
Your Honor, currently she has 2 different curfews in 2 different courts. Would this court mirror the felony courts?
She's not gonna be working now. She's not gonna be working at night now. And she's got a very serious open felony case. She's not picked up an assault. I'm not gonna let you be out at night.
That's
No.
not the only reason why I had the curfew though. I have kids that have after-school
But
programs.
you can't do this stuff. You don't have a license.
Everything doesn't consist of me driving. That's not why, the only reason why they mirrored that. I share literally everything with my mother. So she helps me get my kids back and forth to school. She helps me get my kids back and forth when it comes to their after-school programs and things like that. She lives on completely the opposite side of town. So every time we try to do everything, I'm never gonna make it in the house by 7 o'clock. That's the whole reason why they extended it.
Okay, look, I'll give you till 10 o'clock at night. Okay, just be home by 10. That's it.
And of course, getting the kids to school in the morning, I think that's why they
Yeah.
did 6.
I'm okay.
And 10 to 6, Judge?
10 to 6.
Thank you, Your Honor.
I'm okay with that. Just don't be a danger to my city. That's all I'm literally asking. Okay?
I'll get your recent date in a minute. I got one more person.
Okay, thanks.
I'm really unhappy with you, Mr. Waters. When does it stop? 14 theft cases you have in your background. You're now charged with your 14th theft case. 14. How old are you? You're 21 and you have 13 prior theft cases? I see, Jillian, I see that a lot of them are like kind of bunched up. there's like at least two different pattern of 4 theft cases that are all together. I don't know what that's about. I mean, I haven't done a deep enough dive into his cases, but what's going on now is that your lawyer wants me to give you a PR bond. I know that you're asking me, please, but the problem is though, is if we let you out, are you going to pick up a 4th case, perhaps a 15th theft case? I know that you're going to tell me little bunnies jumping in the woods, that of course it's not going to happen. I'm going to have a halo. I know that's what you're going to tell me.
Look, I got numbers, I got witnesses.
So, Your Honor, what he's trying to say is that he understands that all of these pending cases involve the same gas station, the same officers. And we'll be looking into the contact that's made between him and those officers in all those cases. But he has been out of trouble, with the exception of what happens on this property. And even, like I said, even the PC with this theft case, it's not in this court, but it's shaky in my opinion. And also the evading as well, Judge, that I was originally on, he's backing up from the officers. He's walking slowly. When the other officers get there, he's still at the location. He didn't evade, I would argue. But it met PC, and so we're gonna fight that. But it's not an evading where he just took off running.
13 prior theft cases. Who do you have in your life that's out to help you?
I got my baby mama. I got a baby on the way, you know, and I've been staying out the way.
Oh my Lord. You have a baby on the way.
I've been staying out the way, I promise you.
Mr. Waters is expecting his very first child. Him and the mother are together. She's very supportive. She was here last week when he was initially arrested. So they're working together
Let me
to
ask you this.
create a life for their
You
family.
want your baby to be like you?
I don't even want to be like my dad. I promise.
Where's your dad?
I don't know. Somewhere in Katy. Been on my own side, I was 12. I've been home, you know, I understand about them deaths, what I used to do back then, but that's not going on.
All these are from 23 and 24. What do you mean back then?
This ain't been going on though, like just ever since I came home, when you gave me the PR, I ain't been doing none of that no more. I just been staying out the way. And these same officers just keep on harassing me, jumping out on me, and I can't even go to the store to get
you have the same officers that keep listen out when you're trying to think of something to say, you're not listening. If you know that you have the same officers that are coming after you over and over and over, yet you continue to go back to the same gas station over and over. Jillian,
Judge, I mean, I'm sure it's probably a condition of his felony, but a condition can definitely be that he has to stay away from the gas station. That seems to be his only, like, the only thing I see that he has done is that he either lives around there or he continues to believe that because they sell him things that he didn't have any issues, that maybe he is or is not allowed, we don't know, to be there. To his knowledge, he is allowed. But that seems to be the only thing he's done wrong since I've represented him.
what I'd like to do, number one, is I would like to compile a list of every theft case that he has, every single place that he's picked up a theft case from. Number two, I want to know where he's going to go. I'm not taking your word where you're going. I want to know, and I want to talk to them myself where you're going to go. So I want to know. And just your baby mama, I don't know.
I got numbers
Okay,
right now.
we'll get there, but I'm not letting you out to roam the streets.
I'm not
because-
roaming no more. I got somewhere to stay. I'm not roaming.
We'll get his address and
And
have him.
I want to know every single theft case here. Where are they from? Why? Okay. And then if he has nowhere to go, I want to reach out to the MAC and see what we can do to provide him. And you need to start working. You have way too much time on your hands, and you are the epitome of self-destructive behavior. You need something to do with your life, Mr. Waters. You need to get a job. So this is what we're going to do. And we have a a job fair that's coming up. Hold on a second. Is that the fresh start? Yeah. Can you make him a copy? So what I'm gonna do is, I'm not gonna let him out now, but first thing I wanna know is I wanna know where he's gonna go when he gets out, number one. Number two, I wanna compile a list of all the theft cases, where they're from. What I'm gonna do is I'm gonna put a monitor on him. And then number three, he's going to meet me at the fresh start because we're gonna get his ass a job. A full-time job. I'm going to be at that fresh start fair. And I expect you to be there because you and me are going to get you a job, one way or the other, somehow. I'm going to be working that thing, and I'm going to expect you to show up to that thing at 9 in the morning when it starts, if I let you out. I haven't decided yet. That's where we're at, okay? Thanks. Q. Pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. Morning, Mr. Davis. Sir, you were charged with evading arrest or detention. On that case, you're facing up to a year in jail and or a $4,000 fine. You're also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That kicks it up to a Class A, so you're also facing a year and or a $4,000 fine on those cases as well. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 31st, 2025, the officer observed the defendant's vehicle run a red signal light at the 3400 block of Live Oak Street in Harris County, Texas. The officer further observed the vehicle completely failed to stop at a red signal light and activated his emergency equipment and conducted a traffic stop. The officer made contact with the defendant, who was observed to be behind the driver's seat of the vehicle, and the defendant stated that he does not have his identification card with him, and the defendant gave a fictitious name of Fisher Leroy, with date of birth January 1st, 2006. The officer ran the name through NCIC and found a DPS picture that does not remotely resemble the defendant. The defendant was asked if he was given the correct information, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle and sprint away despite giving him orders to stop. The officer ran after the defendant and observed the defendant get into another vehicle, the passenger side. The other vehicle drove away, and the officer gave the last direction of travel over the radio, but was not able to locate the vehicle. The officer walked back to the defendant's vehicle, secured it, and conducted an inventory check, finding a debit card inside with the name Kendrick Davis. The officer ran the name through NCIC and found a hit with a date of birth of 2/10/2003 with multiple Class C warrants, and ran a driver's license check with the defendant's picture and with date of birth. The DPS picture matched the defendant, and he was able to positively ID. And that's it, Your Honor.
So I'm going to find that there's probable cause to go forward on both of your cases. The reason I'm bringing you out now is because there's no bond that's set on your cases, and we have to set you a bond. One of the things that I use to determine on what to set a bond is how dangerous you are, because I've never met you before. I don't know you. And all I know is that you've got a birthday in 5 days. So he's on bond for an aggravated robbery now, right?
Yes, Judge. It's my understanding, I think it was a 2B, it looks like. I don't believe bond conditions and everything were put in place until a few days ago.
Okay. So the charging instrument was filed November 13th of 2024. I think that you may well be right. In that case, it says here, a Kendrick Richard Davis hereinafter saw the defendant heretofore on or about August 12th, 2024, did then and there unlawfully while in the course of committing a theft of property owned by yada, 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 with intent to obtain and maintain control, intentionally and knowingly cause bodily injury to the complaining witness by using and exhibiting a deadly weapon, namely a firearm. Complainant McSweeney advised that defendant Davis proceeded to pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on his face with his foot. Complainant McSweeney stated that he was in fear for his life and felt severe head pain as a result of the assault. I see that he has also picked up an evading arrest in a motor vehicle the day after our two cases. How? Oh, I guess that's how they caught up to him, right?
So
They
they
must
caught up to
have.
him and they found him, and that's when they arrested him on that, and then he got picked up on me, I believe.
Okay, so what happened in that case? Is he like driving 100 miles an hour? Is he just?
Yes, Judge, it says that the officer observed the defendant conduct an improper turn and failed to turn into the correct designated lane. They activated their lights and sirens, and the defendant evaded at speeds of 90 to 115 miles per hour for 3.5 miles on the highways and multiple residential and business streets.
Okay. I think that you are an extreme danger to our public, and I'm going to do everything in my power to protect our public. The first thing I'm going to do is I'm going to order you not to drive. You will be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what is going on in your life. I don't care if there's a burning building. You have to say 50 kittens. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes, sir.
I'm also putting in this affidavit that you're not supposed to be in possession of any weapons as well. If I find that you have a weapon, because I don't know if you're going to get out or not, and because these cases, because of the nature of the aggravated robbery, because of the nature of this one, I'm making his bonds high, I'm going to set them at 20,000 each.
So can I make an argument?
Yes,
Okay.
absolutely.
you,
I
Judge.
don't want to get ahead of myself, please. Yes.
So I was appointed to Mr. Davis this morning. I was able to talk to him a little bit in the holdover. We are requesting PR bonds for both of the cases. He's 22 years old. He's lived in, or I'm sorry, 21 years old. He's lived in Houston his whole life. He has a lot of family in Houston. His grandparents, mom, daughter, and siblings. Prior to being in custody, he was working at Builders First Source for around a month. Mr. Davis also lives with his grandfather who has cancer. Mr. Davis is his caretaker, is my understanding. Mr. Davis has no savings and was found to be indigent by the court, so we are requesting a PR bond.
I think that he is an absolute, just a complete danger to our public. I can't possibly give him a PR bond due to the nature of both of the charges that you are facing now. I think that you're a flight risk. You've done everything in your power to evade capture. You've produced false names. So I find by clear and convincing evidence that you're an extreme flight risk. You're a danger to our community. And I'm going to set your bonds each at $20,000. I don't know if you're going to be able to post bonds, but if you do, I'm going to order you under house arrest if you do get out. And I'm going to order you to obtain a GPS monitor on your ankle. Like I said, you will be signing an affidavit with me today, promising me you're not to be in possession of any weapons and not to drive any vehicle whatsoever for any reason. If you do, I can have a contempt hearing. Do you understand?
Yes, sir.
So I guess the felonies are set for April 7th. I don't like to set them out too far just in case. If you want to, we can do up to 30 days. It's up to you.
That's perfect.
And then we'll come back. I don't know. We'll see what circumstances have changed, and then we'll go from there and just keep us in the loop.
Okay, thank you.
All right. I need you to sign this for me. I need him to sign bond finish with Felicia, and then after that, it's pretty done. Okay.
Do we excuse?
Yes, ma'am.
Thank you.
And thank you for everything. You were Edward Johnson. Since 22. Interference. Failure to ID as a fugitive. Failure to ID as a fugitive. Failure to ID as a fugitive. Assault. And now to moi. You now stand charged with assault of a family member. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On November 23rd, 2024, in Harris County, Texas, an officer was dispatched to a disturbance call. The officer met with the complaining witness who stated that she was in a dating relationship with the defendant for about 2 years. The complaining witness stated that she and the defendant had been in verbal altercation a few days prior, and the defendant had just returned that they were not sleeping together. The complaining witness tried to enter the residence, but the defendant closed the door on her arm, causing pain. The complaining witness stated that the defendant and her then got into a tussle where the defendant eventually bit her bicep area, causing pain. The officer observed a bite mark as one.
So he just picked up a felony case as well. What happened on that case, please?
That's going to be through opposition marijuana for 5 pounds. In that case, Your Honor, on April 1st, 2025, law enforcement officer performed a traffic stop because the license plate did not return to the vehicle. The defendant was the driver and the sole occupant. The defendant stated he had some weed in the car. The defendant had an open warrant from Galveston for possession of marijuana and a misdemeanor warrant for an handgun. The law enforcement officer arrested the defendant and located 4.38 ounces of marijuana in a bag in the backseat.
Can you run an NCIC? How many charges does he have now? And how many jurisdictions, please?
Yes, Your Honor. Total charges, Your Honor, or just?
Okay, CA, possession of marijuana. So an open possession of marijuana and a UCW in Galveston?
Alamos?
That's correct, Your Honor.
So he has 2 open charges over there as well?
He has a felony possession of marijuana and then the unlawful carry weapon out of Galveston.
Mr. Johnson, I'm sending you now for a drug test. I want to know what, if anything, is in your system. You're to come right back. On one ankle, I'm going to put a scram so I know that you're not consuming alcohol. On your other ankle, I'm going to put a GPS device so I know where you are at all times. You are not allowed to drive. You're going to be signing an affidavit with me today, promising me you're not going to drive. I'm now also giving you a curfew of 7 p.m. to 7 a.m. If I find that you're out past curfew, I'm going to make your bond so high, it will hit the stratosphere. Do you understand? I don't know what we need to do. Obviously,
Alamos? I needed Alamos. Is that Alamos?
that is Alamos. That's Alamos, right? Alamos?
No, this is Melvin, this is Melvin Garcia.
Alamos is Frank's case.
Is that your client? That's your client, right? Oh, that's right.
Alamos,
Right.
and you can, so.
I don't know.
I'm so confused.
Vic,
Yes.
on Mr. Johnson, we're sending him for a test. He has to come back.
Judge, could you go with those conditions for one again? My apologies.
Yeah. So no weapons, no driving, GPS with a curfew of 7 p.m. to 7 a.m. He can go to Galveston for his court date only. Otherwise, he's to stay in Harris County.
Yes, Judge.
No weapons, no alcohol, scram. And then depending on what happens with the test today, we'll go further. I need to know if there's a MOA because, oh, no contact with the complaining witness as well in this case, please. No.
Judge, did you want me to?
Yeah, please.
Are you done with them?
No, because I need to know if there's a MOA that we can have him sign in.
Ariel, can you see if there's a MOAB on Johnson Edward?
I think I may need you to file a new one because the one is scratched out for the no contact here.
That's already signed, but where's the?
Yeah, but they took off the no contact order in this one.
Yeah, they signed,
So-
but they've scratched out and they're communicating with the protected individual.
Right, and I don't want him to have any contact with this person. So, I mean, do you mind filing a new MOA in this case, please? Okay, so we're gonna have you wait over here, or I guess we'll have you take a seat while we get all the paperwork ready. You must come back after the drug test. Do you understand? Take a seat.
Get him to sign
Or-
first. Judge, you want him to sign it and MOAB when he goes?
Yeah, but they have to file.
Just so we know, not to let him sign.
Oh, and he needs to sign the no driving affidavit as well.
Judge, you told him not to drive. The allegation is that he was driving. First of all, Judge, I want to speak on when you told him not to drive, it was because the state told you that he had an ALR suspension. What I've got for you, Judge, I couldn't access it at the time because I don't have access to our closed files. This is an ALR dismissal order.
So, okay.
There was never a suspension on his license at all. He's been good to drive.
But he was also drinking.
Well,
But the concern was that he was drinking. And
But Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
he was drinking allegedly, and the
Yes.
license was suspended.
Yes.
Can you
And-
run his license, please, state?
Your Honor, this should be eligible to.
Did it just become eligible, or when was it eligible? You know what, let's do this. I have a line of people, I've got arraignments. Let me put this off a little bit because this is gonna take a
I
lot
had to
more
go to the
time.
doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response that when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do tomorrow?
I'm already
Let me
here,
look at,
Judge. I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
so what day was it lifted?
4/2/2025, from what I can see on the license. It's the ICC.
And what are the days that he's alleged to be driving?
The second, Judge, let me double check.
And does he have an interlock as well?
Yes, Judge, he has interlock, he was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a layperson who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with this license. There was no ALR suspension ever. The state told you that. That's why you.
A suspension.
It was
and
not
it
an
was
ALR
lifted
suspension. There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal order from Jurisdiction? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing you yours.
Suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
12/6/2024, end date 6/3/2025, and the lift date comes in at.
And then if that's,
I'm not saying you're wrong, what I'm saying is, based on what I can see, is what I can see.
if there's a dismissal order, then that suspension is contrary to law and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, our court order is a court order.
I understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No. We have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast, your head's be spinning as fast as a wheel. Now, you have a CDL, am I right? I'm not going to put you in jail now, but I want to make sure that you're not drinking. So does he have a scram on right now?
Yes, Judge.
Okay, everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the 2nd and 3rd. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pretrial, not anyone else. Do you understand?
Sir.
All right. Good luck, sir.
Thank you, Judge.
Good luck with your appointment, Mr. Judge.
Thank you, Judge.
Counsel. So, guys, please keep it down. If you need to talk, go outside. We have someone that's going to testify here on Zoom. No talking with this case, Joe. He gets charged with a sexual assault upstairs, or he's on bond for a sexual assault.
On bond.
And then he picks up an indecent.
No. Plea bargain down to a class A indecent assault.
The felony court does not do misdemeanor probations, so we had to refile it as a misdemeanor. That's what the plea deal was essentially.
So it was a reduction to a misdemeanor,
Correct.
indecent assault
Correct.
to a 2-year deferred. Okay. So let's do ma'am, what I was going to do is do the plea first and then have you say something after the fact, if that's okay. Are you okay with that?
Only if it's not allowed for me to speak first prior to the plea, then of course, yes, it's okay to speak
If you want to
afterwards.
speak first, then you're welcome to. Is there
Okay.
something that you wanted to say?
Well, I wanted to read my victim impact statement.
Please do. You're welcome to do it.
Okay, thank you. Okay, so I'm writing this statement to share how this experience has continued to affect me long after that night. There may be times where I actually need to take a moment to breathe, actually. Just wanted to go ahead and say that first. When I first submitted this statement, I was overwhelmed. I was still in emotional shock and unsure of what to say and how to say it. I've since come to understand the importance of expressing clearly, not just what happened, but how it impacted every part of my life. This event has completely changed me. I wake up with anxiety. I experience episodes of fear, confusion as to why I did not run, and constantly feel a loss of trust, not just in people, but in places I once felt safe and in myself. Every day I'm reminded of what I've lost. I lost peace of mind. I lost the ability to work without panic, the ease of everyday interactions. Every day I'm reminded of how I got taken advantage of and didn't react as I felt I would have in a moment like this. If this emotional toll has affected my professional life, my relationships, my physical well-being, I can't control my heart rates in these moments of panic. There are true anxiety, full-on panic attacks that I experience still to this day, 2 years later.
At the time of my first statement, I didn't have access to important documents, which are records that might have helped me explain myself more clearly within these 2 years. Since then, I've started the process of requesting my full case file from multiple agencies, medical records, and forensic testing. I have not received those as of today just yet, but I know those documents all exist. It's been over 2 years, and this case has been reset multiple times. A new prosecutor was also assigned only days before this plea was suddenly brought to me. The rapid timeline did not allow me to revise my statement or consult with anyone about how this offer would impact my rights as a survivor or my potential ability to seek justice outside of this criminal court. This statement is not about vengeance. It's about the truth. It's about my healing. It's about ensuring my voice is heard in a process that often feels designed to just move forward without it. Every day since this assault, I've struggled with anxiety, flashbacks, and trust issues that have reshaped how I live my daily life. I still cry regularly from this incident. I still shut down. I still replay everything from the pressure, the coercion, the force, the aftermath of where I try to survive it all without falling apart. And yet I still feel like I have to justify why it broke me. This wasn't just a violation of my body. It shattered my trust, my sleep, my ability to feel safe in my own skin. I've spent nights replaying what happened, and the fear and the disgust and the betrayal. What was taken from me was not just physical, it was psychological and it was spiritual. I'm a hairstylist, and my career is built on one-on-one trust with my clients. Since this happened, I felt constantly on edge with male clients. I find myself backing away from simple interactions. I've lost my income. I've lost my confidence and my own safety in my own body. The job I once had, I lost due to being completely disconnected from my mind and my body. I now know that this man was on deferred adjudication and had a breathalyzer in that car, and yet that night he took his mother's car and drank heavily and violated me when I was in and out of consciousness. The defendant slapped my face during intercourse and violated me. His third time assaulting me that same exact night without consent. I remember him begging me again and again, and I kept saying no. But I couldn't get up. I pushed him away off of me again and again. That is not consent. Me freezing up was fear. That was survival mode that I was going into. And Your Honor, asked that you consider what kind of system lets someone walk away with that and just probation. Even after all of this, I still had to let him drive me home the next day and bought me a Plan B pill. The defense says I had chances to leave, but how do you leave when your body and your brain have been hijacked by fear? The prosecutor told me that juries don't like women and that they don't believe us, and that broke me more than anything. I was told I could be blamed at trial for going to the bar or for texting him afterwards, as if trauma survivors don't respond in ways that help them stay alive. That's why I'm asking you now to please understand that this proposed plea is not justice.
Then I'm not gonna take it. I'm not taking it, Joe. I'm not doing it. Sorry.
Just
I
because
have
she
more-
spoke first?
Oh, I mean, I don't know. All I know is that we have a powerful victim impact statement here. We have a sexual assault being reduced to a misdemeanor, 2-year deferred. Apparently, no one's consulted her regarding this thing, see whether they.
We have been in extensive communication with her this past.
No, sir. No, sir. I
about the plea
barely
and the
spoke
reasons
to you
for
a couple of days ago, sir. I didn't even know you were on my case until Tuesday or Monday it was Tuesday when you first called me. I didn't even know Missy was not on my case anymore. And she gave me the confidence that this would go to trial. She believed we had a very strong case to bring this to trial. She didn't have any doubts in this case at all. And I meet Gabe just this Tuesday. And it's rushed into this plea without even without even discussing with me.
Okay. Thank you, Ms. Echevarria. I appreciate your testimony.
I really appreciate your honor letting me speak before you accepted this plea.
Absolutely, and I'm glad that you were here to speak, get everything off your chest.
Yes.
Anything you need, we're here for you, Ms. Echevarria.
I really appreciate that, your honor. Thank you for letting me get on Zoom, even though I could not physically be there.
Yes, ma'am. I will accept this, but I'll do 30 days as a condition. It's the only way I'm going to do it. So you guys can talk and see if there's something
I
that
think
you
it's
want to
unfair to
do.
my client because normally we do the plea, then we have the statement. Just because she spoke first, now she's gonna bust the deal?
She's not busting anything. I mean,
I'm
I
the
was,
victim. I am the victim. How do you even
please,
speak about? Sorry.
please.
Yes,
It's okay.
He's been coming to every court date. We've been set for trial 7 times. We're actually set for trial this morning.
In the district court,
I'm sorry,
in the district court.
in felony district court.
I get it. She feels like, one of the things that we need to take into account, is I'm not going to do it without 30 days as a condition. I'm sorry, Joe. So you guys can talk or we can set it for trial. It's your decision, Mr.
Can we do home confinement?
Home confinement? No. That's a gift. No.
Can we stand up?
Please.
Okay.
Okay, ma'am.
Officer observed the defendant's motor vehicle stopped on the road facing the wrong side, forcing the motor
Going the wrong way down the street.
stopped on going the wrong way, yes. Forcing multiple motor vehicles to drive around the defendant. The officer observed the defendant's motor vehicle to be on with the defendant sitting in the driver's seat, appeared to be sleeping or passed out. The motor vehicle was in drive with the defendant's foot on the brake. The officer observed an open container of Bacardi rum, a 750 milliliter bottle, approximately 10% full, sitting in the front right passenger seat. The officer attempted to wake the defendant unsuccessfully, which led to the officers being forced to break the defendant's front right window to get into the motor vehicle due to the doors being locked. The officer placed the motor vehicle in the park, and the defendant was asked to step out, and he immediately fell to the ground. The officer observed slurred speech, red bloodshot eyes, a strong odor of an alcoholic beverage, and poor balance. The defendant refused SFSTs. The defendant advised that he had not consumed any alcohol beverages and wished to speak to ask for his lawyer, and was loudly repeating no comment to all questions. The defendant was read the DIC and he refused breath, and a blood warrant was signed. The defendant was transported to HCA Southeast ER to obtain the blood, and the defendant
I think I'm good.
Your Honor, this gets into resisting.
Oh, okay.
Which I understand if you
That's okay.
but it is. So the officer the defendant refused to exit the vehicle, even though the officer was asked to multiple times. The officer had to physically guide the defendant out. The defendant stopped walking while walking to the emergency room with the officer, and advised that he wanted to go to the VA hospital. The officer advised the defendant that he had a search warrant, and the defendant refused to move. The officer grabbed the defendant's upper arm and again advised the defendant of the search warrant, and again he refused to move. The officer then advised the defendant that if he had to pull him inside, that he'd face additional charges. Again, the defendant refused to move. The defendant advised he wanted to go to the VA hospital and tried pulling away into the direction to the entrance of the hospital. The defendant went dead weight and laid on the ground outside and refused to move and screaming at the top of his lungs, "Someone help me." The officers had to be assisted by hospital security and placing the defendant into a wheelchair and transport him to the hospital, and blood was drawn with the assistance of 3 officers holding the defendant down.
Mr. Mallard, do you watch the news?
Yes, sir.
How many people died this weekend due to an alcohol-related collision?
The one that comes to mind, sir, is the softball team. Her mom, her dad is in critical condition right now. That's the latest one that I did see, sir.
There were at least 3 if not 4 different accidents this weekend where people died. There was in Galveston an entire family that was cut down because of an alcohol-related collision of a person who allegedly just completed a DWI intervention course here and a couple months later goes out and then decimates an entire family. In this here now, you pled to a DWI not 3 months ago with above a 0.15. Now you hear on another one, there's alcohol allegedly in the car, the wrong way on the street, completely passed out to where. There is a reason why I do things in life. I don't do it just for shice and giggles. I want to protect my community at all cost. And I think that it is an appropriate condition to not have you near the car. Do you understand?
Yes, sir.
All I care about in this short life is protecting my community. And I'm going to try to do it at all costs. I understand that it may be a hardship to you, but sometimes in life, things are learned when they're faced with difficulty. And now I do not want you out in the middle of the night, and I don't want you near a car. Do you understand?
Yes, sir.
Perhaps in some time, because I'm not an a-hole. I try not to be, right? But it's been 2 weeks since you've picked up this DWI. I shudder to think, do you have the blood back yet?
No, I did not have to get back yet.
Before anything, even remotely getting near, I want to see some proactivity on your part.
Yes, sir.
But you coming up here and saying, woe is me, goes in one ear, goes out the other ear. I care about my community. That's what I care about. That's what matters most to me. And I'm going to protect it at all costs. You understand?
Yes, sir.
So I am willing to work with you on the hours if you need hours to work, but I don't want you out in the middle of the night. Do you understand?
Yes, sir.
Okay, thanks.
Thank you, Yanni.
Please.
And just to let you know, he has started attending AA meetings. He's been attending for the past couple of weeks every night, virtually. One of the facilities that offer the AA meetings, they do offer it, is it at 10?
It's at 9:30.
At 9:30. But his curfew would need to be extended a little bit more. That too.
You can do it at all times during the day. You can do it remotely. You can do it via Zoom. You can do it online. I don't want you out at night. It's not going to happen. Because then if I let you out at 9:30 at night, well, I need an hour to get back home. And then now it goes to 10:30. I'm not going to do it. Their AA meetings are literally all day, every day. You just have to find it. You have to be creative. That's why we have computers. That's why we have the internets to be able to help you.
Yes, sir.
Thanks.
Thank you, Yanni.
Let's roll, nerds. Oh yeah, let's roll, nerds. Yeah, let's roll, nerds. Oh